minutes for rebuttal. Mr. Ackroyd, I see you're already at the podium, so when we get started, if you let me know if you want to reserve time and how much. Please don't use the names of children in this case. We have read your brief and ready to proceed when you are.
Thank you, Your Honor. I'll reserve 5 minutes for rebuttal.
Okay, thank you.
Thank you, Your Honor. Attorney Neil Arnold for the appellant mother in this case. Your Honor, there's only one assignment of error. It's not a complicated issue. The question is, when a third party, in this case the maternal grandparents, file a motion to intervene, what is required? What is to be done? This court has already previously held on multiple occasions when a party files a motion to intervene at the juvenile court, whether it is a intervention as a right or a permissive intervention, you must follow Civil Rule 24C. Now, I have laid out under page 5 of my main brief, what does 24C require?
Counsel, before we get into all that, can I ask you a question about our jurisdiction?
Yes, sir.
I guess I'm just not still sure why we even have jurisdiction of this matter, because it's a motion to intervene that was granted.
Yes, Your Honor.
I can't talk this morning, I apologize. But in other words, it wasn't a denial of a motion to intervene.
That is correct, Your Honor. And actually in my reply brief, well, first, that was a question of jurisdiction that was raised initially.
Right.
And I filed basically why I thought, and then the court said, at least for initial purposes, we'll let the case go forward, and then substitute, re-bring it up. And then in my reply brief, I argued why I believe this is a final appealable order. First of all, this court held previously, and I cite this in page 1 of my reply brief, in re CM, and there, just like in this, it was a relative's motion to intervene, and it was appealed before there was a final dispositional ruling in that case, and this court ruled on the merits. So how could this court rule on the merits of a motion to intervene in the middle of a case unless the court believed, at least at 2004, it was a final appealable order? Then this court held...
It might have been a mistake.
It might have been a mistake, and the court...
As I recall, when I looked at it, it didn't really address the final appealable order issue.
It did not, but I'm arguing this court always is subject to considering its own jurisdiction, and I believe the court would not have considered, wouldn't have addressed the merits unless it believed it had jurisdiction. Now, obviously, that could have been...
Go ahead, sorry, go ahead.
That obviously this court, and again, there's no explicit case law that says it is or it is not a final appealable order, at least out of the 9. So we'll get a ruling, hopefully, one way or the other on that. But I did cite another case out of the 9th, and this is on page 2, State Farm Mutual versus Young, where that was also a motion to leave was granted, and there was appeal, and this court also ruled on the merits. And then I cited other cases from other courts of the district, Ohio Coal versus Kidney, when they specifically held, and I quoted it, the grant of a motion to intervene is a final appealable order. Then there was a case from the 11th district, Conward Township Trustee versus Hazelwood Builders. They didn't explicitly hold it, but they ruled on the motion to intervene. So, again, this court, the law is really in flux. And there are cases on both sides of whether it's a final appealable order, and I guess the court would have to make a determination we were wrong when we ruled on the merits back in 2004. It could say it is a final appealable order, so I'll leave that for the court. But if I can proceed to my only assignment of error. In order to file a motion to intervene, you have to file Civil Rule 24C. There, 24C, and this is on page 5 of my main brief where I specifically put in bold, the motion, that's the motion to intervene, supporting memorandum shall state the grounds for intervention, and you must file an accompanying pleading as defined under Civil Rule 7A. So then we look to 7A to see was a pleading legally provided. And what does 7A say? They say when you file a motion to intervene, there's an answer, there's a counterclaim if you choose to do so, but if it's a third party, what do they have to do? A third party says it's a grandparent who's not an original party. They have to file a complaint if they are summoned under Civil Rule 14. So we go further down the rabbit hole and you look at, okay, were the grandparents summoned under Civil Rule 14? And Civil Rule 14 has two subparts. One is if they are going to be considered a third-party plaintiff, or are they going to be a third-party defendant? Well, in this case, the grandparents are neither. They're not a third-party defendant. No one has summoned them, nobody has sued them. They are choosing to insert themselves into the litigation. So no one is saying, you're being sued or you have something to defend. So they're not a third-party defendant, and I'm arguing they're not third-party plaintiff either. They have no right to participate in the litigation. So on what basis are they a third-party plaintiff or a third-party defendant? Neither of the grandparents have explained it. Children's Services hasn't said how they are one of those. So in order to do a motion to intervene, really there's three parts. There's the 24C, there's the Civil Rule 7A, and then the Civil Rule 14. And basically I'm arguing in this case, the grandparents haven't complied with any of them. So I'm arguing their motion to intervene should be denied. So that's really, I'll reserve the balance of my time unless there's any questions, but that's really the part of my argument. All right, thank you.
Thank you, Your Honor. Good morning, and may it please the court. I'm Jacqueline Corrigan. I represent the appellee, the Summit County Children's Services in this matter. First of all, in response to Judge Carr's question, CSB's chief argument, by the way, is that there is no final appealable order in this case, and therefore this court does lack jurisdiction to consider this matter. Contrary to counsel's arguments, the CM case, the court did not address whether there was a final appealable order. It did proceed to the merits, but without making any kind of holding. And there were other issues involved, not just the issue of whether intervention was proper. Generally, though, orders granting intervention are generally not final appealable orders unless those interventions operate to vacate a judgment. That was part of the point of the State Farm versus Young case before this court, was that intervention did operate as to vacate a judgment. Same thing with the Southern Ohio Coal case out of the 4th District. In that case, the interveners sought to vacate a consent decree. And by being allowed to intervene, it did vacate the consent decree. So that vacated a judgment there. The other cases that Mother has cited to in her reply brief do not actually hold that a grant of permissive intervention operates as a final appealable order. And really, when you look at the flip side of that orders denying intervention are considered final appealable orders, except in some cases in dependency and neglect cases. And also if you look at the operation of Revised Code 250502B to define what a final appealable order is, the test for I'm just going to abbreviate it as an FAO with the court's indulgence, that an FAO either affects a substantial right in a special proceeding, which is what Mother has argued occurs here, or affects a substantial right that determines the action. Well, there's no argument that the grant of intervention in this case to the grandparents determines the action in this case. Is this a special proceeding? Yes, it is a special proceeding. But more importantly, Mother has not shown that granting party rights to the grandparents in this case affects any substantial right of hers. Instead, what she seems to argue in the briefs is that this is some kind of zero-sum game where allowing the grandparents to participate in any way in this litigation somehow abrogates automatically and necessarily her rights. That's not true. And it also acts as a tacit admission by Mother that if the grandparents are permitted to participate in this matter as parties, that somehow they are going to be eventually found to be more worthy of being granted legal custody than she. I'm sure that's not what she intended, but that's how that sounds. But under the existing case law and also under the operation of 2505-02B, this is not a final appealable order. Getting to the merits itself, it is not correct to say that there was no pleading filed by the grandparents that was attached to their motion, to their amended motion to intervene. There was a pleading, one that fit in Civil Rule 7, and more importantly, fit under Civil Rule 8. That pleading was a complaint. It doesn't matter under the great weight of the case law how a litigant captions their pleading. And this is specific to pleadings and motions. Okay? A pleading, of course, a complaint is going to be a short, plain statement of the claim showing that the party is entitled to relief and a demand for judgment for that relief. That is what the grandparents filed in this. Whether it was miscaptioned, a third-party complaint is irrelevant. Like I said, the great weight of the case law dating all the way back to Peterson versus Teodosio in the Ohio Supreme Court says that the caption of a pleading does not control what it is. It's the substance that's contained within that pleading that controls what that pleading is. So pleading deficiencies are not controlling, and that's really the sum and substance of Mother's argument here, is she's arguing a pleading deficiency. And so what she's asking this court to do is to ignore the great weight of the precedents that we have concerning pleadings and to elevate pleading deficiencies over the merits. Like I said, that goes against the overwhelming weight of the case law, and it is CSB's position that we cannot create a new standard under the civil rules for juvenile court cases than we have existing for other civil cases. Plus, Mother asks this court to do that very thing with inapplicable cases. She cited in her reply brief to Glioso, which dealt with service of the complaint, and also to J. Bowers Construction, which again dealt with service of the complaint. Service is fundamentally different from pleading. Pleading involves putting the other party on notice of the claims. Service invokes the court's personal jurisdiction itself, and no case can proceed without that. So that is why the grandparents did provide a sufficient pleading. And one thing I do want to note, because Mother did bring this up in her reply brief, that yes, point of clarification, at the original hearing regarding it before the magistrate, regarding whether the grandparents would be permitted to intervene, Children's Services Board opposed their motion. They did so because CSB felt that the grandmother was not acting in loco parentis, that she had acted as an agent of CSB, but more importantly, that CSB did not believe that with the catch-all provision of Juvenile Rule 2Y, which allows any other party specific or person specifically designated by the court to be a party, that intervention was actually necessary. However, 9 months later, after Mother had filed her objections to the magistrate's order granting permissive intervention by the grandparents, Children's Services appeared at the hearing to discuss or to hear, or for the juvenile court itself to hear the objections to the magistrate's order, and took no position whatsoever on the intervention. Neither did the guardian ad litem. But in this case, because we cannot allow a new standard for how the civil rules are going to operate in the juvenile court versus how they're going to operate in the general division, CSB cannot stand silent on that. And unless there are any questions by the court, the Children's Services Board respectfully asks this court to dismiss this appeal for lack of jurisdiction. Thank you very much.
Thank you, Your Honor. May it please the court. Your Honor, whether the grandparents' motion is called a third-party complaint or just complaint, you still have to look at you still have to follow 24C. And 24C says they have to file 7A. And then what does 7A say? If the third party is filing a complaint, whether it's called a third-party complaint or an ordinary complaint, if the person was not an original party, which the grandparents are not an original party, if they were summoned under the provisions of Civil Rule 14. I noticed the state didn't address that. Were they in any way summoned under Civil Rule 14? They were not. No one is arguing they were. So again, however you want to label and you have to remember, the grandparents themselves say this is just an ordinary complaint. They say we're calling this a third-party complaint. But irrespective, if it's a third-party complaint or an ordinary complaint, take out the word third party, were they summoned under Civil Rule 14? Absolutely not. So they haven't complied with the civil rules, and this court has held it is mandatory that you follow Civil Rule 24, which says you have to follow 7A, which says you have to follow Civil Rule 14. So it's multiple violations. Then the state made a strange argument by granting the motion to intervene. Somehow mom is admitting that the grandparents will end up getting custody. I certainly don't know where that came from. We are preventing them from being involved in the process. It's more than just they may get custody. And I have cited case law on my reply brief, page 4, that says only, and this court hasn't addressed the issue, but only a party can file a motion for legal custody. Now, this court hasn't directly addressed if just somebody off the street could come into juvenile court and ask for custody of a child, but that's an open question. We're arguing if the grandparents cannot get their foot in the door as third party, as a party in the proceeding, they have no right to ask for legal custody. Now that wouldn't prevent the guardian or children's services or one of the other parties to ask the grandparents to get custody. That's permissible, but they themselves cannot participate. Second of all, their attorney can't cross-examine witnesses. They can't subpoena witnesses to come and testify on their own behalf. We wouldn't have to respond to any discovery requests if they're not parties. So it's more than, it's harmless error if they're somehow involved. Once they're involved, all pleadings have to be served on them. They are treated as a party. They have a right to court-appointed counsel. They have a right to participate equally as a mother and father because they are treated as a party.
Counsel, I'm still trying to figure out, though, how is that a substantial right? Sorry. In other words, because I think that's what the CSB was arguing. How is it a substantial right? Yes, they would be made a party, and yes, you would have to treat them as a party. But is that impacting a substantial right?
Absolutely. It's interfering with the parents' rights to reunify with their children.
How is that interfering with the parents' right to reunify with their children?
Because if the grandparents are involved, they have a right, and the parents are making whatever argument. Grandparents can come in and say, we object, we disagree, we want to subpoena mom to come in and testify. They have a right to run interference in the proceeding. Right now, the proceeding is mom, dad, children's services, guardian. That's it. Grandparents suddenly come in, and they can do basically whatever if they're allowed to permissibly intervene, then everything has to be served on them. Everything has to be approved by them. They're on the case plan.
But why can't that be remedied at the end if mom loses custody of the children to them?
Well, because I think it affects their substantial right. Now, I mean, this court says it's not a substantial right, and the court doesn't have jurisdiction, so be it. But we're arguing that this court has already determined a motion to interview can be reviewed on appeal on multiple occasions. Other courts have held that, and we're asking this court just to hold there's a final appeal order and then address whether or not the grandparents have followed the Civil Rule 24. So, with that being said, Your Honor.
Before you sit down, as it relates to permissive intervention on Civil Rule 24, if the statute doesn't confer a right, the applicant's claim or defense and the main action must have a question of law or fact in common. So we're in juvenile court, And the applicant's claim in a juvenile dependency, neglect, abuse case, here the grandparent's claim is what? What are they claiming to get permissively intervene?
Well, according to Children's Services, it's because they stood in local parentis. But when I asked the grandmother on the stand, why are you intervening? She said, just to make sure the kids are being treated well. And I put that in my brief, and I cite exactly where she says that. So she's not claiming, I need to intervene to protect my rights, I need to intervene because I have parental authority over them, or they see me as a mother figure. It's that I just want to make sure that they're being treated okay by this process. That is why I'm asking to intervene, and she said that. So I'm not sure what their interest is to begin with.
Okay,
All right.
with that, your time is up.
Thank you, Your Honor.
Thank you. Thank you both sides for your presentations. The court will take the matter under advisement, issue a